Okay, I'm Sandy Mayson. I'm an assistant professor of law at UGA School of Law, and I am here with the first distinguished speaker in our faculty speaker series, Professor Christopher Slobogin. To give the briefest of introductions, Chris is the Milton R. Underwood Chair in Law, an affiliate professor of psychiatry, and the director of the Criminal Justice Program at Vanderbilt Law School. He's a prolific law scholar whose work has had a profound influence in an array of fields, notably criminal law and procedure, especially with respect to policing and technology, mental health law, and the law of evidence. We're thrilled to have you with us, Chris. Thank you so much for coming.
Well, thank you for having me.
To start, this is going to be a very informal conversation about the project you're presenting later today. Mm-hmm. So to begin, could you just give us a brief description of that project?
Well, what I'll be talking about is the general topic of policing in a technological age. Because what's happened to policing is just like in every other walk of life, technology has taken over. Police have begun using technology in aggressive ways to carry out their investigations. And I think that requires us to rethink some of the basic tenets of police regulation, and particularly how the Fourth Amendment should be construed in this particular situation.
And what do you propose in this particular piece of work?
Well, I think one thing that needs to be thought about is whether we should adhere to this idea that if the police conduct a search, whatever that may be, probable cause is always required. That is more or less what the Supreme Court's held, and I think that's a mistake. Because what it does is, first of all, it creates an incentive to declare vast types of police enterprises as non-searches. Because if you declared a search and need probable cause, then very often the police wouldn't be able to carry out it at all. And I think the better way to go is to define search very broadly, the way a layperson would, as looking for something or examining something. And then once you have that baseline definition, then decide what kind of justification is necessary. And it shouldn't always be probable cause.
So to what extent is this argument an argument for a revamping of Fourth Amendment doctrine? And to what extent are you arguing for supplemental regulatory regimes beyond the scope of the Fourth Amendment?
I think it's in the eye of the beholder. You could say this is a revamping of Fourth Amendment doctrine, but I actually think there's precedent supporting what I'm arguing. For instance, the famous case of Terry versus Ohio held that the police only need reasonable suspicion to carry out a stop, which is a detention short of an arrest. So that's this proportionality idea I'm talking about in action. It's the court saying, well, a stop is less intrusive than an arrest, so you don't need probable cause, you only need reasonable suspicion. I think the same kind of reasoning ought to be applied to searches. Some searches are not as intrusive as other searches, and therefore not as much justification ought to be required for the less intrusive searches. Now, you could say that's a revamping of Fourth Amendment law because I'm trying to apply the law of seizure, proportionality principle applied in seizure cases to search cases, but I think the logic follows easily from the seizure cases to the search cases. So I could also base what I'm arguing on precedent, and specifically Terry versus Ohio in that line of cases.
Okay, so Terry and the reasonable suspicion standard, we have these two standards in the seizure context, reasonable articulable suspicion and probable cause, and only two. So if we were to translate those two thresholds to the context of digital searches or access to digital information, it would require some kind of line drawing. Is it possible to draw that kind of a line?
Yeah, I think it's a good question. I think that's the difficult. I think intuitively what I'm arguing makes a lot of sense.
Yeah.
But practically, you can run into grave difficulties, both in terms of what you're talking about, the justification levels that we would need to think about creating, but also how you rate the intrusiveness of a given search. I think in terms of justification levels, Fourth Amendment law already recognizes at least three, not just two. It's probable cause, reasonable suspicion, and then relevance, which is the standard that's required for subpoenas. It's a pretty low standard, but I think it's significantly different than the reasonable suspicion standard. And so that's what I would do as far as the justification levels are concerned. Then in terms of figuring out how intrusive a search is, yes, that's a real problem, and people have made good arguments that that's one reason to adhere to the idea that if it's a search, you need probable cause. Let's have a rigid standard, even if it has the problems I've outlined, because it's just too hard to implement. This proportionality principle. But nonetheless, what I've tried to do is suggest ways in which intrusiveness could be measured with respect to where the information is located, the type of information being sought, and the amount of information being sought. And I think ultimately it would have to be decided by a legislature or maybe a court. I'd actually prefer the legislature do it. And then the courts just look at what the legislature does through the prism of the proportionality reasoning process and figure out whether it adheres to the basic ideas I'm outlining.
It's so fascinating because you have this elegant framework for assessing intrusiveness and the idea of a proportionality principle that should govern the justification required for any given degree of intrusiveness. And then you also have another framework, which is you suggest 5 different regulatory categories of searches or of access to data. Can you say a few words about those
Yeah, I
5
will. Let me
categories?
back up and say one more thing about what we just got through talking about. It's what I'm proposing, I think, is not only possibly consistent with precedent, there's also statutory precedent. For instance, the Electronic Communications Privacy Act recognizes a number of different justification levels depending upon the kind of evidence being sought. So there's actually some precedent for what I'm talking about statutorily. Now, going to your next question, yes, in the paper that I'm be presenting today to the Georgia faculty, I talk about 5 different categories of technologically driven searches. Suspect-driven searches, what I call suspect-driven searches, which is where we have an identified suspect. Profile-driven searches, where we don't have an identified suspect, but the police have a profile they hope will help them identify possible suspects. Event-driven searches, which do not involve either an identified or a profiled suspect, but rather are situations where the police are trying to investigate a particular event, usually a crime. And then fourthly, what I call program-driven searches and seizures, where the police are collecting the data that will subsequently be used for suspect profile and event-driven searches. And finally, a situation where a private individual comes forward with information, which I also creates its own significant and unique problems.
Do you see any one of those categories as more challenging than the others?
I think they're all challenging. I think probably the most problematic is the profile-driven search category. And it's not to say police haven't used profiles in the past, they have. But with the advent of algorithms and artificial intelligence and machine learning, you could see computer scientists getting very excited, along with police departments, at trying to figure out a way of anticipating crime, a Minority Report kind of regime. So right off the bat, people are very leery of profile-driven searches. And what I suggest in the paper is a number of limitations that does not, on the face of it, prohibit profile-driven searches, but the limitations are so stringent that it might, in practice, mean these searches could not be carried out.
That's something I was going to ask you about because, of course, it's happening already, right? The risk assessment is happening all over the place. We've both written about that. And one of the limitations you propose as a proportionality constraint is that now you can help clarify this for me, the intrusiveness of the digital access of the profiling analysis has to be proportional to the hit rate.
So I think the proportionality principle ought to apply here, just as I was saying earlier, it should apply in the situation of suspect-driven searches where the police are trying to get a lot of information about an identified individual. In the profile situation, the way I'd apply that proportionality idea is that the creators of the profile should have to be able to show that the hit rate, which I define as the rate at which the profile identifies criminals or people likely to commit crime in the near future, that hit rate should be proportionate to the intrusiveness that's associated with the records being accessed. Now, that's a mouthful, but the idea is that if the profile is only accessing public records, you don't need a very high hit rate. But if in order to make the profile work, or the police are accessing more personal records, more private records, then the hit rate has to be quite a bit higher. And I think it's fair to say right now that no profile that the police have, or at least no profile I have seen, comes anywhere near the kind of hit rate one would need under the proportionality principle to access personal records, bank records, phone records, that kind of thing. So that's one reason I think profiling would be difficult to carry out if my particular approach were followed.
That was going to be my question. Would any of the current programs survive? But to clarify for the audience, in case people aren't familiar with the hit rate terminology, so when you say hit rate, you mean if we have some algorithm that's assessing the likelihood that someone has engaged in or will engage in what? Any criminal offense or some specific offense?
So that's something that has to be figured out. I mean, I personally think as a normative matter that we should not allow profiling at all unless the profile identifies a person who will commit a serious crime, either a person who's already and just recently committed a serious crime or a person who will commit a serious crime in the future. You can see why that would be very difficult to do. And that's why I say no profile comes close to the hit rate that would be necessary to access anything other than public records. There's also another way in which the hit rate plays a role. Let's assume the profile's fine in terms of what we just got through talking about. But I think the proportionality principle would also require that the hit rate justify the action the police takes on the basis of the profile.
Right.
And since, again, we don't have any hit rate close to 50%, even 30%, I would argue the police can't do a stop, much less an arrest, based on a profile until these profiles get much better. At most, it might justify short-term surveillance.
Excellent. I think that, believe it or not, we are approaching the end of our time. We are indeed. It's been quick, but it's been a pleasure. Thank you so much, Chris.
It has been fun. Thank you very much.